Are you confused by the term probate? Hi, Nancy Beauvair here with Agape and Next Steps. Over the course of the last few weeks, I have had a large number of people ask me what exactly probate means. At its core, what probate actually means is that the court is validating the will of the deceased person in the jurisdiction in which they passed away, stating that it is a valid will and also that the executor who is named in that document has the legal authority to now act on behalf of the estate of the deceased. Sounds like a mouthful, but basically what it is validation of the will and the executor to give them the appointed authority to act now on the behalf of the deceased person. In other words, now they have the legal capability to access investments, access property, real property and otherwise, and to make decisions, file taxes, do what has to be done in order to settle the estate of the deceased. Probate laws are similar across all jurisdictions in Canada because we are all operating under a common law, although Quebec is the exception. Quebec actually does operate under civil law, which is why there are some nuanced differences in estate laws in Quebec versus the rest of Canada. But essentially, it's the same kind of process. When somebody does pass away, there is a process where the will and the death certificate have to be processed by the court in the jurisdiction, and then you receive what is called a grant of probate. That grant of probate is what is going to tell land titles offices and banks and investment firms that the executor now has the legal authority to get inquiries, get information, and to deal with those assets of the deceased. Now, what happens if there isn't a will or if the will is invalid? Well, then what happens is the court will appoint what is known as an administrator. They're not known as a trustee or an executor because they haven't been named in a will, in that legal document. So instead, they're acting as an administrator on behalf of the deceased, appointed by the courts, that again gives them the legal authority to deal with the assets of the deceased person. Now, we also in Canada do not have estate taxes, but we do have probate fees, and those vary widely across the country. We have everything from jurisdictions that have no probate fees to a fairly significant portion in Ontario, BC, and Nova Scotia. At the time of making this video, those are the three jurisdictions with the highest probate fees. Typically, regardless of jurisdiction, the probate fees are charged on a sliding scale depending on the value in the estate. Now, here in Alberta, my home province, they're capped at $525, regardless of the size of the estate. So these probate fees, though, can become fairly significant on some of these estates. If you have a large estate and you're paying 1.7% of a probate fee on that, that has to be paid to the court before they release that grant of probate that allows you to operate on behalf of the deceased. And because those fees have to be paid before you get the grant of probate, often the executor will have to pay that money out front and get reimbursed from the estate after they do receive that grant of probate. Now, not every estate has to be probated either. Again, make sure that you are current in the jurisdiction in which you reside, but typically smaller estates that don't have a large value don't require probate. Banks, financial institutions typically have their own threshold, and they will allow the executor to access the account with a copy of the death certificate and a copy of the will showing that you are the executor in smaller items. And again, those thresholds will vary depending on the institution. So be sure to check that out. But typically, if you have a smaller estate, you don't require probate. Now, I've just pointed out about the probate fees, and often that's what people focus on when they're trying to avoid probate is the fees. But really, it's not really the fees that are at issue here. The bigger issue about probate is the length of time that it takes for this to happen. Depending on, again, the jurisdiction, it can take anywhere from 4 weeks to a year. One case that I'm dealing with, it's been over 2 years since the person passed away, and they still don't have grant of probate because there were some complications. So it can take a long time to get that grant of probate, and that means that assets are frozen and can't be dealt with until that grant of probate has been received. If you have a house that needs to be sold, you can't sell that house. You can't transfer the title to the estate of, to the executor in the estate of the deceased until after you've received that grant of probate. So that adds time, that adds cost, because you have to maintain that home until it can be sold. So there's a lot of things to be taken into consideration when you're doing your estate planning. I always like to suggest to people that wherever possible, you want to name beneficiaries. You want to make sure that you are keeping as many of the assets as possible out of the will and the estate and needing to be probated. If you can pass on assets by naming beneficiaries, those pass completely outside of probate. They're not subject to any fees. They can be released practically immediately. And in the case of insurance products, most times there is absolutely no tax required to be paid on any of those either. So it's a tax efficiency as well as a probate efficiency issue to do your planning in a way that mitigates the taxes that are due, mitigates the amount of assets that are going to be required to go through probate. And that's where it makes sense to start bringing in professionals to help you with this. I'm a certified executor advisor, and I guide people to help them understand what it is that they can do. Now, I'm not a lawyer and I'm not an accountant. I'm not going to give you that advice. But what I can do is make sure that your planning is structured so that when you do go see the lawyer, when you do go see the accountant, you're making a more efficient use of your time and you know a little bit more about the questions to ask when you're going forth. It does make sense. I gave a talk last week, and one woman in the audience raised a very valid point. She said that she finds that so many people don't want to spend any money on professionals when it comes to their estate planning. And that's what I have found in my experience as well. People often think that they can do this on their own, and yes, they can, but in a lot of cases, they might miss specifics that can make their estate planning smoother, make things go through quicker, and less painful for the loved ones, their heirs, and their beneficiaries that they leave behind. But let me ask you this. If you spent two, three, even $5,000 getting proper legal advice, getting proper tax and accounting advice, having somebody like me come in and help you structure your plan, but you were going to save your estate $10, $20, $50,000 in taxes that didn't need to be paid. Doesn't that make sense? Isn't that a good investment? Though there's that expression, penny wise and pound foolish. You want to make sure that you're not one of those people. So as usual, I have an article over on my website. I invite you to click the link over in the description box. It'll take you to the article. If you have any questions, please reach out. Always happy to help. I appreciate you joining me this week, and I look forward to sharing more with you next time. Thank you, and bye for now.